Once you turn around.
He said, how are you doing?
How you doing?
Good morning, you're Kevin Ross.
Yes, ma'am.
And so Mr. Ross has two motion to revoke probations, cause number 24, DCCR 1198, on probation for the offense of a deadly weapon in a penal institution, and in 24-1199, evading arrest or detention with the use of a vehicle. Mr. Burbank has filed motions asking that I set bonds in these cases. Give me just a second to get this pulled up.
Judge, if I may, just
Yeah, go ahead.
inform the court, we have discussed this at length, Mr. Burbank and myself. I have made several requests to DPS via my investigators to bring the new evading. Typically, we could proceed on a motion with just a probable cause affidavit. The alleged egregiousness of this evading lends to an absolute need for the video, which is what Mr. Burbank wants. Considering DPS has not brought that, I feel like in fairness, I cannot oppose a bond for this defendant because I think that the video itself will be dispositive of either he was driving or his brother was driving, is my understanding. I've made requests of the trooper and they just have not brought it in. So June 13th.
And if I may
Can't imagine why it
add,
would
Judge, I
be.
will represent to the court, I do have an affidavit from another individual, but I need the video, because we could really shortchange, get right to the problem.
Who's the trooper?
CJ. And I'll try to reach out again.
I'll reach out this afternoon after docket. So I'll figure, it looks like there are other allegations.
I'm sorry, Judge.
And so,
Garcia. Jordan Garcia.
I'm sorry.
Jordan Garcia, I had seen Judge on that.
In addition, Your Honor, the magistrate court,
Yeah.
in my motion, I also add, if you were to consider a bond, some other requirements that I believe would be necessary.
And I've spoken with his probation officer where she understands the situation.
So we've got allegations of the evading with a vehicle and just an evading on June 13th. And then possession of marijuana from June 13th as well. And then drug patch, tested positive for cocaine. Out past curfew, June 13th at 1:39 a.m. Okay.
I have the PC on that today, Judge, if that would help.
I think I might have it right here. Let me take a look at that as well. Here's what I'm going to do today. I'm going to hold the motion to set a bond. We're going to, I'll contact DPS as soon as docket is done to see what it takes to get that video. If we can get it quickly, then everybody can look at that and see where we are. If for some reason we cannot, then I will reevaluate and set bonds at some amount based on the nature of the allegations and all of that. So, but
Mr. Faye's reach out as well, Judge.
okay,
This morning, you're on the.
Okay.
They can-
if you'll let them.
When they know the court is.
If Detective Bates will let them know that he's gonna call them or I'm gonna call them, so maybe they can get that very quickly, and we'll go from there. All right, go back with the bailiff. At the most, we'll reset it for a couple of weeks, but if we get that, then we'll figure it out as soon as we have an answer today. I'll get with both of you. Okay, go back with the bailiff. And then you have Carrington Scott.
I can announce if you don't want to announce.
No, we need to get them out, please. Oh, okay. Have we seen or heard from you? This is Mr. Smith's case on Carrington Scott. Good morning. Are you Carrington Scott?
Yes, ma'am.
And this is 25 DCCR 0538. Mr. Scott's charged with robbery. Mr. Burbank?
Your Honor, I have reached out to Mr. Smith. I understand what's going on. There is a video that is missing, and he was attempting to try to get it. The court can do two things. It would probably be dispositive of this case if it received, it's a convenience store robbery, and some of the cameras were missing,
Okay.
the tape. If you want to reset it for a couple of weeks, I don't know when Mr. Smith will be back.
I'm sure Ms. Malfino or Mr. Nichols can
We
step
can
in.
handle it, Judge, and I just want to let the court know, Mr. Smith has documented that he did reach out to the detective on August 12th. I'll be happy to call him.
Okay, thank you, Ms. Malfino. So we'll just,
Convenience store video, some of it was already erased, so I think I agree it would be dispositive.
okay.
He's dispositive of it. I mean, he's rejected the 15 years from Mr. Rojas, Judge.
All right, we'll just do maybe about 3 weeks. That'll give Mr. Smith, when he gets back, or Ms. Malfino, sounds like she'll step in and try to take care of getting whatever information they can, so that we'll, if they have it, you can see it. If they don't have it, then we'll figure it out from there as well.
I'll do it.
All right, thank you, Ms. Malfino.
I think that's all I have.
It is. Thank you, Mr. Burbank. Mr. Lewis, you have Derek Ardwan. It's a sentencing. Good morning. Good morning. Are you Derek Ardwan? And Mr. Ardwan was previously in court in cause number 25 DCCR 0350, entered a plea of guilty to the second-degree felony offense of sexual assault. The agreement was for a cap of 6 years in the institutional division of the Texas Department of Corrections. I have received the pre-sentence report. Has everyone had an opportunity to review that?
We have, Judge.
Any additions or corrections?
None from defense, other than something I'll clear up my argument.
Okay,
I have nothing, Judge.
go ahead.
Well, Judge, if you read the PSI, it's several times Mr. Ardwan does take responsibility for what happened, for his actions. I know there was some talk from the PSI writer that seems like he was minimizing or still deflecting some of his responsibility in what happened. I did speak to Mr. Ardwan about that. He said that toward the end of their interview, he understood more what the PSI was saying, because there was two people from probation there at the time.
Yes, sir.
And so as the second person started to intervene, he understood, and so he totally takes responsibility for what happens. He understands the situation. He shouldn't have been in, him or the complainant, during that situation. He was going through a situation with his girlfriend. It wasn't his wife. It's not his actual stepdaughter. His girlfriend, and started getting more attention from the stepdaughter than he should have, and he went along with it. Shouldn't have, but he did. It wasn't a situation where someone was underage or anything like that. She was definitely at the same age. Being in a relationship with him, they had started hanging out a lot more, almost in a dating scenario, if you will. And then it escalated to the point where they were together that evening. Nothing of force, anything was happening. To my client understanding at the time, he thought everything was consensual that was going on. It wasn't until later, until this investigation, that he realized her stance or argument of her being intoxicated to the point where she couldn't give consent, legal consent or anything during the activity. I would like to point out with him, when you look at his criminal history, he has not had any type of criminal history since 2001. So since he was in trouble that one time or that last time there, he has done everything he can to try to keep his life on track and not revert back to any of the old activities he had when he was younger. My understanding is, he does have a lot of family support. I've been in touch with several members of his family that have reached out to me. My understanding is that the mother of the complainant is still very supportive of him. And to the point where, even though he moved out and was away from her and everything like that, she still wanted to pursue their relationship and work on their issues. He is asking that the court consider community supervision in this situation. I think it definitely could be appropriate here in a situation where he's a registered sex offender at this point, so he will be able to get any of the attention or that he needs through any sex offender classes or through their registration, as well as I think that there's several vehicles available through probation that could help with any other additional issues that he does have. So at this point, Judge, we are asking the court to consider deferred adjudication in the situation with Mr. Ordway.
Thank you. Ms. Malvino?
Judge, although the PSI reflects that they were unable to contact the complainant, the notes in the case reflect that our office has, and she seemed cooperative and wanting to go forward with the prosecution based upon that, based upon the nature of the offense, the circumstances that even Mr. Lewis himself has described with respect to, she may be considered a legal adult, but the difference in their age is quite substantial. Obviously, he took advantage of the fact that she was making bad choices with respect to drug and alcohol use and got herself in this position. So on her behalf, Judge, the state would argue for the 6 years under the cap, but defer to the court's discretion, of course.
Thank you.
And if I just may confirm, in case the question arises, he has already completed the sex offender registration paperwork.
Oh, yes.
Yeah,
Yes,
I think we did that at the plea.
Just check.
Thank you. So I guess my thought is on this, I don't disagree with Ms. Malfino that prison time isn't necessarily warranted. It sounds like you got yourself in a predicament that you're way old enough and grown up to know better. She wasn't a minor. There was a lot of things that looked like they were consensual up until a certain point where y'all probably, it sounds like we're both so intoxicated, you clearly didn't know what was going on. 6 years, you're out in a few years. There's no treatment. There's none of that I think would be helpful. And so I think, to me, the better and maybe even more difficult thing for you is probation, because this type of probation is not going to be easy. So what I'm going to do is find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to defer all proceedings and place you on probation for 10 years. There's two things that are, well, let me finish and then I'll go through some other stuff. I'm going to order a $1,000 fine. I'm going to order that you follow all of the rules and conditions of probation, and that includes entering and successfully completing a licensed sex offender program. To successfully complete the program, you also have to admit what you did. So it's very important that you get in that program, you take responsibility for your part in what happened and how you got to this position so that you're never in this position again. You're obviously already signed the paperwork and understand that you will be required to register as a sex offender. If you don't register timely, then that's a violation of your probation plus another felony offense. And so you've got to take care of everything you're supposed to while you're on this probation. So the good thing about that is it's a deferred probation and there's not a conviction. The good thing for me and potentially Ms. Malfino later is that by doing this deferred probation, that cap of 6 years is off the table. Okay, that's over today. I didn't give you prison time, so that's gone. If you violate this probation, I then have the entire punishment range, which is 2 to 20 years in prison if you violate. So there's no coming back and saying, I want the 6 years or I violated and I've got the whole range. I'll look back at this and I'm sure I'll be reminded at what their argument was, and it's not likely to be 6 or less. You understand?
The judge then provided the defendant with the required court documents, confirming that the sentence followed the terms of the agreement and that the right to appeal had been waived. The court also emphasized one of the most important conditions of probation. The defendant must have no contact or communication with the victim under any circumstances. The judge explained that even if the defendant continued to have a relationship with the victim's mother, he could not visit any location where the victim might be present, including her workplace. If they happened to be in the same public place, it would be the defendant's responsibility to leave immediately and avoid any interaction. After confirming that the defendant understood these conditions, the judge wished him well before concluding the hearing.